Is Ethan. Nice to see everyone in the comfort of our own homes and the safety of our own homes during this crazy time that we're living in. We're here today to talk about, Medicaid and, unraveling the myths of Medicaid that a lot of people might have, and what you've heard from neighbors and friends. And we're just here to dispel, those myths and get to the truth of what Medicaid really is. I'm going to break this presentation up in, three different areas. One, I'm going to talk about, how to protect assets and the rules of Medicaid. Then I'm going to go into those common myths that a lot of people have about Medicaid. And then we're going to just jump into some examples. And feel free to, type in your questions. And then we'll go over those questions at the end of the presentation, like Patrice said, okay? So let's just hop right in here. So first slide here is, we're protecting assets. And one of the common ways we protect assets is we do a 5-year gift and wait plan. So basically what that means is we're gonna gift a portion or a substantial portion of your assets, wait 5 years, and then be able to apply for Medicaid. And Medicaid will not be able to see that gift that you made. So how does that work? Well, there's a 5-year look-back period that Medicaid has, meaning that on the date of application, Medicaid looks back 5 years to see if any gifts have been made. If you make a gift 5 years and 1 day ago, Medicaid will not see that gift. So what we do is we set up an irrevocable trust, or you gift directly to your children, depending on what the situation is. Usually we gift to a trust to protect those assets even further. So we generally say, if you're healthy, this is a great tool to use. However, you are gifting to an irrevocable trust. An irrevocable trust means that you're gifting, you're gifting this asset, you're losing all control and ownership of this asset. So you better trust your child or the trustee that you gift this money to pretty well. And that might not mean that this plan is right for everyone. And that's just something that we have to talk about and go over your personal situation, okay? So that's the 5-year gift and wait plan. Medicaid does not see any gift 5 years plus that you've made, okay? So next common tool that we use to protect assets is the caretaker child exception. So that is when a child moves in with mom or dad or both and provides care. It has to be nursing home level of care. And that money gifted to, or not gifted, paid to the child is a proper transfer. That's not an improper transfer, it's not a gift. There's also a great tool that we use that the Medicaid rules allow, that if you live with your mom and dad for 2 years prior to them entering a nursing home, the house is gifted to them, penalty free. So it's a great tool, but there's a lot of planning involved. There's a caretaker agreement that we prepare. The mom and dad have to have the receipts, have to have a time, they have to keep their time, keep track of all the things they do for mom and dad during those 2 years. But if it's done properly, it works like magic, and it's great. It's great for mom and dad, it's great for the child, and it's great for Medicaid, because essentially what Medicaid is saying is, thank you, child, for taking care of mom or dad and by not having them go to a nursing home, and having Medicaid pay for nursing home level of care for those 2 years. So once again, this is not for everyone. There's a lot of steps that need to be taken in order for this to work. But like I said, when it works, it's magic. Okay. So next great tool that we use is gifting within the look-back period. So gifting within that 5 years. I generally say that this is used during crisis planning, what I call crisis planning. That means that, mom or dad, they fell and broke their hip and they go to a nursing home for rehab, and you find out, well, they can't really come back home. It's not safe for them to come back home. The doctors are saying you need to stay, you need 24/7 care. You need skilled care at a nursing home. At that point in time, you can gift roughly half of their assets to children, to other family members, whatever the case may be, and essentially protect and save those assets. The other half would have to be transferred to a pooled trust or used to purchase an annuity to pay for their care. Okay, so at this point in time, we're talking about a single applicant and not a married applicant. A married applicant, as we'll discuss later, different rules. And for a married applicant, you can essentially save everything for the community spouse. The community spouse is the one that doesn't need Medicaid. This is generally, crisis planning is generally for a single applicant that needs nursing home level of care now. And there is no planning done prior to this. We generally tell clients you can save about half of those assets. So once again, I should mention, gifting is not illegal. Gifting before the look back period or during the look back period, it needs to be planned according to Medicaid rules. And Medicaid rules say, hey, if you gift, that's okay, but we'll penalize you for that gift. We will, if you gift $6,905, we will not pay for Medicaid for 1 month. So if you do the math there, if you gift $69,000, that's 10 months of Medicaid that Medicaid will not pay for. So we take that all into consideration, and we use the Medicaid rules to, protect assets. All right. So we got the next slide here. This is a wonderful tool that's in the Medicaid rules. If you have a disabled adult child, it can be transferred penalty-free to that disabled adult child. So the penalty that I talked about last slide doesn't apply to a disabled adult child. Usually that is someone that's declared disabled by Social Security, that's receiving Social Security. So it doesn't matter what the amount is, either 5,000, 100,000, 500,000. If the Medicaid recipient transfers money to a disabled adult child, it is penalty free. And usually we set up a trust because that disabled adult child probably has their own benefits. So we set up a special kind of trust called a sole benefit trust to protect their assets. Sole benefit trusts, as I noted here, do not have a Medicaid payback provision in it. So you're not transferring this to a disabled adult child and Medicaid is eventually going to take this money. It is always going to be safe either for the disabled child or other children or other family members after the disabled adult child passes away. Okay, so this is the next tool that we use, and this is for a married couple. there is protections from spousal impoverishment. And this has been in the rules for decades, that Medicaid does not want to impoverish the community spouse when the other spouse needs nursing home level of care. There's a lot of policy behind that. Particularly, they don't want to have one spouse need Medicaid immediately after the spouse that needs is in the nursing home that needs Medicaid. They don't want two people needing Medicaid back to back. They want to make sure that the community spouse is taken care of. So what does that mean? So if a married couple and one spouse needs to go to a nursing home, well, the house and the car, the house is exempt up to about $560,000. The car is exempt of any value, and up to $128,640 in assets are exempt. And there's a minimum and a maximum. The maximum is this $128,000 figure. This is called the Community Spouse Resource Allowance. We can determine how much a community spouse is able to save once we take a look at all of the assets that the married couple have, okay? So we take a look at bank accounts, retirement accounts, annuities, anything that the married couple own, and it either jointly or in their individual names, both spouses' assets count for Medicaid purposes. The other great thing here is that there's unlimited income that is protected for the community spouse. So the community spouse's Social Security pension is all safe for them. And what we do as part of this planning is we take whatever amount above the community spouse resource allowance and we convert it to an income stream for the community spouse. So that means, you know, if they are $50,000 over the limit, and they have to either spend down $50,000 to qualify for Medicaid, or you take $50,000 and convert it to an annuity for the benefit of the community spouse. Obviously, everyone wants to save as much money as possible. They don't want to spend $50,000 on a foolish purchase. They want to save that money, you know, down the road. Ultimately, that's a discussion that you would have to have with, you know, your elder law attorney in order to make the best choice. So once again, we talked about the general rules of how to protect assets. Now let's talk about, you know, these myths that a lot of people have about Medicaid. So I'm going to be talking about the same things maybe 2 or 3 more times, but these are complicated things, so I want to make sure that we hammer it home. Okay, so unraveling the myths. So myth number 1, I must sign my house over to the nursing home. You know, this is a myth. The home is exempt for the community spouse. And remember, the community spouse is the spouse that is living in the community that doesn't need Medicaid. And it's exempt for a single individual if they sign a letter of intent to return home. The letter of intent to return home is, you know, even though they have no intent to return home, Medicaid rules, you know, permit someone to write this letter. It's a simple letter saying that they intend to return home, and it's an exempt for them while they are alive. There's a caveat here, you know, beware of estate recovery. If that single individual owns that house while they are on Medicaid and they pass away, estate recovery can attach a lien on that house. I'll talk about this more later, but keep that in mind when we talk about this more in depth. Estate recovery is a Medicaid rule, and they attach liens to property at the Medicaid recipient's death. So what we do is we take in account the house when we do our Medicaid planning for the single individual. Okay, so myth number 2 here. We must spend down everything we have to get my spouse on Medicaid. You know, as we discussed, this is a myth. The spouse is entitled to the home, the car, and all of that spouse's income with no limit to that, and up to $128,640, which is called the Community Spouse Resource Allowance. So any funds in excess of the CSRA can be used to purchase an annuity for the spouse, like we talked about, or spend down, pay off debt, make home improvements, buy a new vehicle, whatever that might do to benefit the community spouse. So that example that I gave before, about if you're $50,000 over, you can, if you have home improvements that you need to do, you need to get new windows in the house, you need to get a new driveway. Now that is the time to do those improvements, and Medicaid says, hey, that's a qualified transfer of assets. You can do that. So once again, every situation is different. Maybe you can spend the money down on these certain items, but you need to talk to an attorney first to go over your finances, go over your assets, and make the best decision possible for everyone. All right, myth number 3 here. I must use my IRA to pay my spouse's nursing home bills. This is a total myth. So the IRA is a countable asset for Medicaid purposes, but you can convert the IRA, you can have a qualified rollover for tax purposes. You can roll that IRA over to a Medicaid compliant annuity to benefit the community spouse, and that IRA can be paid to that community spouse. So here's an example here. John and Sue are married. They own a home, $125,000 in investments, and John has a $450,000 IRA. Sue goes into the nursing home. John, he gets to keep the home and the car. He gets to keep the $125,000 in an investment account because that's part of his CSRA, his Community Spouse Resource Allowance. Then he can convert his IRA to a Medicaid compliant annuity, which will pay him a monthly benefit, because remember, his income, he can have an unlimited income for his benefit over the course of his life expectancy. And there you go. His wife qualifies for Medicaid, and he doesn't have that $10,000 a month bill, and he can use his funds for the rest of his life. The IRA, obviously, that is, once the money is received by John, that's a taxable event. So you rolling over an IRA or another qualified taxable account to an annuity, that's not a taxable event. It's once you receive the money. So he will pay taxes, but he can spread those taxes out over the years so that his tax bill isn't as much. And he's taking the lesser of two evils here. He's paying the tax bill a little quicker than he wanted to, but he's saving tens of thousands, if not hundreds of thousands of dollars paying the nursing home. All right, so unraveling the myth of everything I have is a countable resource for Medicaid purposes. This is a myth. We talked about the home and the car, that's exempt. There's also prepaid funeral and burial plots of any value, that's exempt. For the community spouse and for the institutionalized spouse, the spouse that needs Medicaid, the Community Spouse Resource Allowance for a married couple, and tangible personal property, that's all exempt. All right, so, you know, we see this all the time, you know, that I see this all the time where a married couple come to me a year after they've already been in the nursing home, the spouse has already been in the nursing home, and just spending down their money to the nursing home, where they spend $120,000 over a year. And I wish they would have came to me the year prior, where I could have told them this money could have all been saved for the community spouse. This could be, and the spouse could have qualified for Medicaid a year ago. So it's all about timing. If and it's not their fault. I mean, these rules, they're not posted anywhere, but it's there. You know, there are Medicaid protections that's right in the rules that we follow. All right, I told you we would talk about Medicaid estate recovery, and here it is. You know, unraveling the myth that after I'm gone, the state of Ohio will take my house. So that's a myth. Estate recovery permits the state of Ohio to collect on any assets in the name of the Medicaid recipient at the time of their death. So as part of our planning, we try to avoid Medicaid estate recovery entirely. That once a person qualifies for Medicaid, we ensure that their account, that Medicaid recipient, is his all of their assets is below $2,000. Okay, that Medicaid recipient. And if there is Medicaid estate recovery, it's only on that small account. When there is a house that the Medicaid recipient passes away, still owns the house, the state of Ohio will place a lien on that house for the amount of the Medicaid claim. So that begs a question. So a $100,000 house, Medicaid puts a $500,000 lien on that house. The state will not take the home, nor will they force a sale. They're not in the foreclosure business. They will put a lien on that house and wait for that sale to be completed. If the sale is completed, the title company or the bank will have to pay off that lien before transferring to the new owner. So that's how Medicaid gets paid. They put a lien on the house, kind of like a mortgage, that they will get paid once the house is sold. So let's take that example that it's a $100,000 house, and then Medicaid puts a $500,000 lien on this house. The house is transferred to child at death. Child can, you know, keep the house, can live in that house, can rent that house out. But if child ever wants to sell the house, well, the proceeds will go to the state of Ohio at that time. But the caveat is you can negotiate with the state of Ohio about the Medicaid claim. So you can tell the state of Ohio, I'm never going to sell this house. I'm going to keep this house. Instead of you keeping this lien on this house, though, would you accept, you know, X amount of dollars to release this lien instead of all of the proceeds if I would sell the house? You know, and generally that might work. It all depends on the situation. And it's called Medicaid negotiation. You negotiate with the state of Ohio, the Attorney General's office. But hopefully we never have to come to that point. With proper planning, we avoid this altogether. But obviously some things fall through the cracks. So there are options if Medicaid does put a lien on a house. All right, so now we're into the example phase of the presentation here. And I wanted to point out with these examples, you don't have to be a millionaire to protect assets. You know, having a house and some money, I mean, that's enough to protect assets. I mean, you can save as much money as you want. You know, whether that's $100,000 of assets, whether that's 500, whether that's $1 million, that's your money, and the Medicaid rules allow you to protect as much assets as you want. So I wanted to share that first, and let's get into these examples. So John and Sue are 70 years old. They're relatively good health and have about $1.2 million in total assets. So we're talking about a 5-year gift and wait plan. So they establish an irrevocable trust and transfer $700,000 to it as a gift for their children. So they have relinquished all control of the $700,000, and their children are the beneficiaries and most likely the trustees of this trust. So 8 years later, Sue needs nursing home level of care, and she enters in a nursing home. So John and Sue, they have about $500,000 remaining, plus their house and car. The $700,000 is safe. John gets to keep the home and the car, and he gets to keep the maximum CSRA of $128,000. He annuitizes the remaining money as an income stream payable to him. And Sue's nursing home bills are now covered by Medicaid. Using this plan, they just saved all of their money. So here is a spousal annuity example where a married couple, they didn't do a 5-year gift and wait plan, but this is a straight spousal annuity plan. So John and Sue are married, they own a home, $125,000 in investments and $450,000 in an IRA. And then Sue goes to a nursing home. John keeps the home and his car. John keeps $125,000, and he converts his IRA to a Medicaid compliant annuity that will pay an income stream over the course of his life expectancy or earlier. So I don't know if I mentioned that earlier. So there's Medicaid tables that determine what a person's life expectancy is. You don't have to go to a doctor. You don't have to get a doctor's opinion on what your life expectancy is. They just look at your age, and that's all they look at. So if the Medicaid table says that your life expectancy is 15 years, you can have an annuity paid out for 15 years or earlier to you. If you have a $450,000 IRA, you probably don't want to have that paid out over a year to you because of the tax consequences of that, the income tax consequences. But you might want to have that paid out over 5 or 7 or even 10 years. If you don't need those funds, you can stretch it out as long as you want. That way the tax liability is lessened. At the end of this, Sue qualifies for Medicaid. So here's a care contract example. And usually this is with a single applicant. Probably over 90% of the time it's with a single applicant here. So Sue probably needs to go into a nursing home because she has developed dementia, or she's just, not just getting around as well. She needs help with meals, help with bathing, help with her medication. Well, in this example, she's not declining cognitively, and she does not want to live in a nursing home. So Sue's daughter, she's willing to provide the care that Sue needs to remain in the home. So Sue and her daughter, Pam, enter into a care contract that pays Pam $16 an hour to provide Sue the care and oversight that she needs. At this point in time, Sue doesn't have the cash to pay Pam. Payment pursuant to the care contract is secured by a mortgage on the home. So in this example, Pam will get paid once she sells the property, or once she once the house is transferred to someone else, that mortgage will get paid to her. Okay, so in this example, Sue didn't have the cash proceeds in order to pay her daughter. That's not always the case. Sometimes Sue might have the cash to pay for the care, and that's fine too. And so you don't have to go through a mortgage and a promissory note in order to get paid. It all depends on the situation. But this transfer to Pam with the mortgage is a perfectly legal and proper transfer. Pam just needs to make sure she keeps her time, keeps good notes of what she's done to provide for Sue. And there's a lot of things that need to go into consideration before they enter into this care contract, including Sue needs to go to a doctor and get a doctor's opinion that the care is needed. So she needs to have the stepping stones in place in order for this plan to succeed in the future. And that's something that we would talk about during our meeting if a client came to me and wanted to pursue this plan. Okay, so I love this plan. This plan gets me excited to do Medicaid planning, and you'll see why at the end here. So John, he's single. He had a stroke and he went to a nursing home. So this happened out of the blue. He didn't do any Medicaid planning. This is what I call crisis planning. So he owns a home with an auditor's value of $150,000. He also has $125,000 in various investment accounts, either stocks, mutual funds, or even a small checking account. It all totals about $125,000. John gifts the home to his 2 children. This creates a penalty period of 21 months when Medicaid won't pay for John's nursing home care. Okay, so since he gifts the home, that's a $150,000 gift. And Medicaid is saying, hey, you gifted here. Because you gifted, we're not gonna pay your Medicaid bill at the nursing home for 21 months. But to pay for his care during this time, he transfers his $125,000 in cash and investments to a pooled trust. Each month for 21 months, his income from Social Security and pension goes to the nursing home, and the pooled trust pays the difference. When the 21 months is up, Medicaid says, okay, we'll start paying your Medicaid because the penalty period from that improper transfer is up. Then, so he qualifies for Medicaid at that point in time. In the meantime, John's children sells the home for $200,000 when Medicaid only sees $150,000 improper transfer, because Medicaid only looks at the auditor's value of the home. And most people see that the auditor's value is far less than what the fair market value is. I mean, so the children just see a $50,000 increase of a gift, and Medicaid, they don't care, because all they care about is the auditor's value of the home. John's children can sell that home anytime from the moment that they receive the home. All right, the last little topic that I wanted to discuss with you guys is the Medicaid application process. It is cumbersome and it's a frustrating process. And even clients that they don't have much money at all, and they actually qualify for Medicaid without an attorney's help. I have clients that contact me and I explain to them, hey, you qualify for Medicaid now. You can just apply yourselves. They still want to have an attorney apply for them because of this process. It's a frustrating process, like I said, dealing with Job and Family Services and pushing the application through. Because, especially in Cuyahoga County, but it's all over the state of Ohio, Medicaid applications take a minimum of a month to get processed, and we've seen Medicaid applications take 3-4 months, even 5 months, for actually to be approved because they are so backlogged with applications. Let's just go through, the basic Medicaid application process. Application is submitted to the county Job and Family Services. A long list of documents is needed, identification documents, financial statements, and at least a year's worth of financial statements. I usually tell clients we need at least a year's worth. Right now, like I said, it's taking months for the Job and Family Services to process an application because they're so backlogged, and because of COVID. I mean, COVID is making their job, even more difficult. But here are the documents that are needed. Obviously identification documents, medical cards, financial statements, and at least a year's worth. I say a year's worth. They could ask for 5 years worth because of the 5-year lookback period. But because they're so backlogged with applications, it's taking them so long to process, these applications. They're only asking for a year's worth. And of course, they need proof of income statements from pension, Social Security for both a married couple. So the documents are submitted to Job and Family Services. As your attorney, then we handle all questions and comments by them, and we ultimately just push the application through. We tell them we submitted everything. Let's get this taken care of. I mean, it's sometimes as simple as that. If you can get a hold of someone at the county, if you don't get a response from them, either an approval or a denial after 45 days, we can appeal to the Bureau of State Hearings, and that is typically a phone hearing. Especially now with COVID, it's a phone hearing. It's with a hearing officer, the county, and you as the applicant, and obviously with us as the attorney, going over why the denial or why the lack of action has taken place. If there is a denial, then obviously we appeal to the Bureau of State Hearing. Myself and other attorneys in the firm, we do not do risky Medicaid applications. So we follow the law, and if there is a gray area in the law, we tell you before we actually apply, because we want to make sure that the application is approved. And it being denied and going through all this process, we don't want this financial and personal burden on the applicant and their family. So with that being said, we hardly ever have denials in Medicaid applications. But if there are, or if there is, then we go to the Bureau of State Hearing to appeal that decision. There's a further appeal called the administrative appeal level. we rarely ever go to this level. It's with a written response, and even rarer, the next appeal level then is to the county court of common pleas. So the judge will then hear our case. And that really is about it. We had that technical glitch there, but we made it through.